Welcome to Talk Law Radio with attorney Todd Marquardt of the Marquardt Law Firm at marquardtlawfirm.com.
Welcome to Talk Law Radio. I'm Todd Marquardt, on the radio, on podcasts, on Facebook, on YouTube, and at talklawradio.com. Now it's time to discover your legal issue blind spots by listening to me talk about the law on the radio. And today we're going to be talking in Sunday afternoon for legal analysis with Mom and Pop with me, Todd Marquardt. So today we're going to be talking about a court case that the mainstream media isn't talking about. It's Wright versus Jones, which is a Court of Appeals case out of Waco, Texas in 2023. It's a case about a married couple with children from previous relationships who wanted to use a simple solution for a complex situation. The complex situation being a married couple with children from previous relationships, and the complexity arises from Texas family law, notably community property law, and Texas common law about real estate interpretation of deeds. The question we want to learn about today is whether a revocation of a ladybird deed conveying land by a married couple after the first spouse dies is effective to revoke the transfer of interest upon the death for both spouses or only the surviving spouse. Tell your friends to listen to Talk Law Radio to discover hidden legal issue blind spots. Subscribe to our YouTube channel. Just go to YouTube and find the magnifying glass to search for Talk Law Radio. Then look for our Lady Justice logo in the red, white, and blue colors. Then click subscribe. If you want to get notified when new videos become available, also click the image of the little bell. So like I said before, this is a case about a married couple with children from previous relationships who wanted to use a simple solution for a complex situation. The people involved in this case are Billy Wright, that's the father, Jean Wright, that's the stepmother. Lewis is Billy's son. You might want to take notes here because you got to keep everybody's name straight. Dorothy is the stepdaughter of Jean Wright. That's the stepmother. Jean Jones is Jean Wright's biological daughter. And so then the first thing was a deed prepared and signed from Billy and Jean to Lewis, dated in January 2023, that reserved a life estate with power of sale. We call those deeds ladybird deeds here in Texas because there was a law professor that used an example one time, and instead of using names like Bob and Joe and Sally and Sue, he just used the name ladybird. And so from then on, everybody thought of that type of deed as a ladybird deed. So the deed was signed in January 23rd, 2015. Billy died just a couple of months later, March 1st, 2015. Billy also had a last will that left everything to Jean, his spouse. So this is where it gets a little complex. And it reminds me of a friend from church who was telling me about his own situation. His mom and dad lived long lives together as an only marriage, with all the children being of that marriage. And his mother died, leaving everything to his father, which seemed like the natural order of things for my friend, who just happens to be like 40 years older than me. But anyway, so his father had all of the assets in his name, and a few years later, he wanted to get remarried to this new lady. And my friend from church, he wasn't very concerned about that because he wanted his dad to have a companion. He wanted his dad to be happy. And so he didn't have any objections about that. Well, sometime after their marriage, Dad wrote a new will, unbeknownst to my friend from church. And then Dad died, leaving everything to stepmother. And my friend from church didn't really need an inheritance. He had his own money, he had his own retirement, his own savings. And it made him a little bit uncomfortable that somebody outside of the family would inherit everything, but I'm sure that his dad just wanted to take care of his new wife. Well, sometime after that, stepmother died and left all of her assets, including my friend's father's assets, to her children. Now, this made my friend from church very upset because he didn't think that that would have been his dad's intention. Well, this is why it's so important to talk to a good estate planning lawyer to talk about all the what ifs and could be's type situations so that you understand what you want to do and how to make it legally effective to carry out your wishes. So this is a very similar case that I've been telling you about. So back to the case. Jean, the stepmother, signed a durable power of attorney on May 12, 2016, appointing Dorothy as her agent. Remember, Dorothy was Jean's stepdaughter. We don't know which marriage that is from. So Dorothy, as Jean's agent, signed a revocation of the Lady Bird deed a couple of years after that, August 13th, 2018. And Jean also signed it. Jean Jones, Jean Wright's daughter, began living with her mother a couple of months after that, October 1st, 2018. So the names are kind of similar, so that's why I suggested you take notes. So remember, Jean Wright was the stepmother. Billy Wright was the father that died. Just happens that Jean Wright's daughter is named Jean Jones. Well, on October 9th, a year and a few days later, in 2019, Jean Jones, the daughter, traveled away from home to visit some friends and family out of town for a few days. And when she returned, the gate to the entrance of the property was locked. She had to climb over the gate to enter the property. Her key no longer fit the door lock to the door of the house. And Louis, Billy's son, told her that she was no longer allowed to live there and she could gather her belongings and leave. But he refused to allow her to enter the residence. So a couple of years, or 1 year after that, Dorothy, as Jean's agent, signed another revocation deed on March 5th, 2020. Then Jean Wright entered the nursing home. And following that event, Jean Jones, the daughter of Jean Wright, filed a lawsuit asserting a trespass to try title action and requesting a declaratory judgment that the revocations were effective and that Louis had no present, future, or remainder interest in the property. Louis filed a counterpetition requesting a declaration that as of the date of Billy's death, he owned the property by himself, 100%. So the question here is, who's right? Is it Louis or is it Jean? Well, the district court found in favor of Jean Jones, the daughter, finding that the revocations were effective and Jean Wright owned the property 100% and that Louis had nothing. Well, Lewis filed a motion for a new trial that was denied, so Lewis appealed the judgment. The question again today is whether a revocation of a ladybird deed conveying land by a married couple after the first spouse dies is effective to revoke the transfer of interest upon the death for both spouses, or only the surviving spouse, or only the deceased spouse. We'll answer all these questions and more. Stay with us. I just want to mention that Marquardt Law Firm sponsors the show, and attorneys at Marquardt Law Firm focus on business and estate law, including last wills, living trusts, and tax-protected inheritance plans. Also, old businesses and new businesses, which might have issues with corporations, contracts, LLCs, family limited partnerships, and we can represent those who are facing problems from lack of planning, like in county court, district court, or probate court. Okay, back to the case. Let's find out how the court decided whether Lewis owned the property or whether stepmother Jean Wright still owned the property, because she was still alive and living at the nursing home. The court begins with an analysis interpreting the language of the ladybird deed. In construing a written agreement, the appellate court ascertains and gives effect to the parties' intentions as expressed in the agreement. The appellate court discerns the intent from the words written into the agreement. The agreement must be enforced as written, and the court will consider the entire writing and attempts to harmonize and give effect to all the provisions. The court bears in mind the particular business activity sought to be served and will avoid a construction that is unreasonable, inequitable, and oppressive. Deeds are strongly construed against the grantor and in favor of the grantee. So we go back to this ladybird deed, which is just a cute name for a life estate with power of sale. So the deed had a reservation clause that reserved the right of the grantors to continue living there for the rest of their lives. Ordinarily, when a life estate is measured by two or more persons, the life estate ceases upon the death of the last party. But it matters how the words are written. Words matter. Meanings of words matter. There was a court case, Neely versus Brogdon in Austin, dated 1919, says a life estate is one which may last during the life or lives of one or more persons in being. That means alive at the time. A testator may create successive life estates in the same property as where he gives to a named beneficiary for life, and then to another person for life, and so on to any number of persons, provided that there are persons in being at the time it's supposed to take effect, and each such estate to begin upon the termination of a preceding life estate. In the context of limitations, a life estate terminates on the death of the last grantor, if it's so written. But the court, in its analysis, wrote, here, this document did not expressly create successive life estates that began upon the termination of a preceding life estate. Okay, so you got that part. Now we have to bring in the community property aspect of Texas law. Property is presumed to be community property. You can rebut that presumption by proving that it's separate property, but the presumption is that it's community property. As such, one spouse can dispose only of that spouse's 1/2 interest in community property. So the presumption is that each spouse owns 1/2. The presumption can only be overcome by language which clearly and without equivocation manifests a contrary intent. Because the presumption that the property was community property, the court held that Billy and Jean each reserved a life estate in their respective 1/2 interest in the property. Nothing said that upon the death of one spouse, the deceased spouse's 1/2 interest would be conveyed to the surviving spouse for the remainder of that spouse's life. Therefore, Billy's 1/2 interest vested in Lewis, his son, immediately when Billy died. So Billy had a 1/2 interest because it was a life estate that terminated. As to his life, 1/2 went to Lewis. Neither revocation of the Lady Bird deed was executed by Dorothy as Jean's agent was effective as to Billy's 1/2 interest that vested in Lewis. So based on the foregoing, we conclude, that's the court, that title to Billy's 1/2 interest in the property vested in Lewis immediately upon Billy's death. This means that Lewis and Jean Wright, the stepmother, are co-tenants in the property. And it just made me wonder, as you probably are, is this what Billy and Jean intended to happen when they signed that deed back in 2015? I'm not sure. I wasn't there. But some of my clients that have been married with children from previous relationships have wanted this result, where maybe this was actually Billy's property, or maybe he spent most of his money on it and he wanted it to go to his biological children, but he didn't necessarily want to force his wife to move out. So this would accomplish that. Sometimes people worry about the conflict between the stepmother and the stepson. And if you want the surviving spouse to be able to live there without the stepson, we can achieve that result using a deed, a last will and testament, or a living revocable trust. It just has to be written in the right way. But remember that I can't give you legal advice today on the radio and on podcast and on YouTube because we don't have an attorney-client relationship. This is just general information about a published court case out of Waco, Texas in 2023. Hopefully you learned something enough to get some ideas, to call an attorney, to hire an estate planning attorney, and to develop these plans for yourself, because legal advice must be tailored to the specific circumstances of each case. Okay, I just mentioned that Lewis and Jean, stepson and stepmother, were co-tenants. A co-tenancy is formed when two or more persons share the unity of exclusive use and possessions in property held in common. That means they could both be there at the same time. Now, Jean Wright was in the nursing home, so she wasn't there. That leaves Lewis with the right to be there by himself. You might be wondering about the effectiveness of Billy's last will and testament. So he had this Lady Bird deed that's specific to the property described, and then he also had a last will. Well, does it matter what the last will said? And the answer is no, because the deed controls the outcome of the disposition of that property. So it's outside of the purview of the executor of the will. And Billy's will cannot be admitted to confirm their intent to leave everything to the surviving spouse because this is known as extrinsic evidence. extrinsic evidence is not permitted if the deed is not ambiguous on its face. A mere disagreement about the proper interpretation of a deed does not make the deed ambiguous. The instrument is ambiguous only if, after the applicable rules of construction are applied, the deed is reasonably susceptible to more than one meaning. But this deed was written clearly and expressly and had an outcome that none of the parties understood. That doesn't make it ambiguous. The court said, "We do not find the language in the Lady Bird deed in this case to be ambiguous, and as such, we may not consider the parties' reciprocal wills to ascertain the intent of the parties in this deed." Okay, so did you learn something from this case? Well, we know that Lewis won 1/2. Applying the appropriate standards, the court concluded that the trial court's declaratory judgment was not supported by legally and factually sufficient evidence. So we have to go back to the rules of evidence in court procedure and all of that. The other thing that we learned is any co-tenant has a right to be in possession of the property in which he owns an interest. But was this the outcome that Billy and Jean wanted? I have to suspect that it's not. And my other question is, why did Jean sign the deed? Because it was only Lewis as the grantee. Now, some people do change their mind. I have to tell you another story about a husband and wife. They were older, and the reason that they were updating their estate plans is because the wife had cancer. She was trying to get her affairs in order. And they had wills that said the surviving spouse gets everything. And then after that, it would go to all of their collective kids. So this was like a real life Brady Bunch scenario. I think the husband had 3 kids. I think the wife had 3 kids. I don't remember the genders. But here's where it takes a turn that becomes interesting, is that the husband died of a massive heart attack. Neither of them knew he had any kind of heart condition. They were expecting her to die from cancer, but really it was him. Well, she survived for some time after that, and she inherited all of the assets. She had all of the assets in her name. But sometime later, she got upset with the husband's kids because they wouldn't call her, they wouldn't visit her, they wouldn't send her greeting cards on holidays. And so she changed her will to name only her kids. Now, that probably wasn't what husband and wife wanted, but she had the right to do it because everything was left to her outright, free of any restrictions. Now, there is a way to leave the assets to your spouse so that they go in a marital trust instead, and then you can have restrictions on your 1/2 community property and your separate property. I hope you've learned something today. Hope you learned about trying to use a simple solution for a complex situation. Not a good idea. You want to see a good estate planning attorney that helps you understand the issues that are unique to you. Don't do this yourself. You want to have a professional involved. And remember, this hasn't been reported by the mainstream media. Tell your friends to listen to Talk Law Radio to discover hidden legal issue blind spots. Subscribe to our YouTube channel. Just go to YouTube and find the magnifying glass to search for Talk Law Radio. Then look for our Lady Justice logo in the red, white, and blue colors, then click subscribe. If you want to be notified when new videos are available, click the image of the little bell. That's it for Talk Law Radio. I'm Todd Marquardt. I'll talk to you later.
This has been Talk Law Radio with attorney Todd Marquardt, brought to you by the Marquardt Law Firm. You can learn more at marquardtlawfirm.com. And be sure to listen to the full Talk Law Radio show Saturday mornings at 11 on 9:30 a.m. The Answer.
Each week, attorney Todd Marquardt talks about the law. His mission with the Talk Law Radio show and podcast is to help you discover your legal issue blind spots. In the beginning, God had one law. Don't eat from the fruit of that tree. Then came the Ten Commandments. Now we have federal, state, and municipal lawmakers that won't stop creating new laws. Laws that might impact you without you knowing it. Listen to the show and drop a line on Facebook or email host@talklawradio.com and let the host know what you think of the show, the topics you want to hear, and whether you want to be a guest.